Our other speaker today is Simon Parker. He has a BA in history and a master's in criminology, as well as a PhD in criminology. And he has been a data steward for GHGA since 2021 as well. And he is currently our data protection coordinator.
Thank you everyone for coming along today. So I'm going to be talking about some of the consent tools that we've been developing within GHGA. So we have 2 tools at the moment, which we think will be useful to the research community. And the first of these really is a modular consent toolkit. So the idea behind this is that to really tackle that challenge that Andreas highlighted around this interplay between specific and informed in a research context. And as Andreas beautifully explained, that's a real challenge when we don't know what those future uses are likely to be. And particularly with the pressures I think all of the research community are under in terms of sharing data for replication and so on and so forth, we don't know how the data that we've produced might be used in the future. So how on earth can we get people to consent in a specific and informed way for its usage? And what we did in GHGA, obviously we are setting up an archive for scientific data, is to try and tackle this problem by thinking about, can we develop modules that can go into consent forms that kind of already exist, that meet those kind of ethical and legal requirements around specific and informed consent, whilst at the same time enabling the future resharing of data. And the way we did this was developing 4 modules in total. So there is a module on data sharing specifically, one around de-identification, another about controlled access to data, and then the final module is consent options. And this final module really gives the data subjects the option to agree or reject to the proposed data sharing. So I'm not going to show that too much today. It's essentially just asking whether you consent or not, and the option to select either one of those. But I'm going to highlight the other modules around data sharing, de-identification, and controlled access to data. So here's our first module, which is around data sharing. You'll notice it says English version. There's also German versions of these texts as well for those of you working in Germany. And as you can see, it says, we would also like to deposit your pseudonymized data in one or more scientific data archives, such as the German Human Genome-Phenome Archive, which is GHGA. This will enable us to share your data with other researchers, helping the advance of biomedical sciences, whilst making sure that your data is being stored securely and in compliance with applicable data protection law. The archive may further process your data to ensure its scientific value and usability. Any request to access your pseudonymized data is reviewed by us beforehand and granted by the archive only after our approval. We only deposit your data in archives that are compliant with European and related applicable data protection law. Your data may also be shared with researchers outside of the EU, but only if equivalent data protection measures are in place. And as Andreas highlighted there, when we say we and in the context of these modules, we're referring, of course, to the project or the researchers who are collecting the data, and the you and the yours refer to the data subject. And so what we want to try and do in this module is really explain that the data they provide will be shared to a scientific data archive. That's kind of the key takeaway from that module. But also we want to give a reason for doing so. So rather than just saying we are sharing it to an archive in a kind of blanket way or a very narrow focus, we are doing so within this broader vision of helping advance the biomedical sciences. So this opens up a fair amount of scope as to the way the data can be used in the future, but at the same time, it still provides a sort of boundary on its potential uses. It's not there for advertising or something completely strange like that. It's about the advancement of science. We also wanted to highlight through the module about how access to that is granted, because that is something that we can be a bit more specific about. And also that where the data is going to be shared. Ultimately, it doesn't have to be GHGA, it can be any kind of scientific archive. But the key point is that wherever it goes, there will be an assessment or a review beforehand from the researchers collecting the data, that the archive will be sort of compliant with applicable data protection law and obligations. One of the terms that we mentioned within the module was around pseudonymized data. And then it's really important, therefore, if you're going to use terms which may not be widely known or widely understood, is to actually explain what they are within the consent form as well. And so this is what we came up with for de-identification, and that's in order to protect your privacy, your data is pseudonymized before we share it with other researchers. This means direct identifiers, such as your name and date of birth, are removed and replaced with a random series of letters and signs. Your pseudonymized data is no longer directly linked to you. The pseudonymization key, which could be used to resolve the pseudonym and re-identify you, is kept separately and remains with the institution who carried out the pseudonymization. The key will not be shared with others. Pseudonymized data are not anonymous. Certain kinds of data, e.g. genome data, could still be linked back to you if combined with information about you available elsewhere, for example, genealogical databases. Due to the residual risk of re-identification from your pseudonymized data, we only make it available under controlled access conditions. And again, so what we want to do here is really explain to the public what it means when we speak about pseudonymization and these sort of specific sort of data protection terms. We also, though, think it's really important that we highlight the risks in the module. It's not really appropriate just to say it's pseudonymized, therefore you're completely protected, because I think we all are aware that pseudonymized data is not anonymous. There is always the potential for it to be re-identified or to link to other data sources. And one of the things that we would suggest is that if you do have a pseudonymization process in place, is to document that and make that available on request to the data subjects. You may get questions such as, if the re-identification is sort of in part dependent on access to the pseudonymization key, why not destroy the key? And of course, you may have to explain that having the key enables them to exercise their rights down the line. If they want to actually withdraw their consent, we need to be able to re-identify that person within the data set and go back in and remove them from the data. But it's really important to have that documented and available so that those data subjects who want to learn more and understand the process in more detail can do so. But it's not necessary to put it all in the consent form, because that's likely to actually lead to confusion. It may be difficult for people to follow and understand, and actually probably then is less effective than having a slightly broader picture. And also mentioned in that previous module, we mentioned that the data is only going to be made available under controlled access conditions. And so, of course, now we want to explain to the public and the data subjects what we mean by controlled access. And again, with the English version, external researchers may access and use your archive pseudonymized data only after a successful application. Researchers must first submit a request indicating which datasets they wish to use, how, for which purposes, and who would have access to the data. Each individual request is reviewed by us to make sure that it is in line with this consent. Only after our approval of a request does the archive grant researchers access to your data. Researchers only have access to the pseudonymized data and do not receive any other information about you from us or the archive. So the key point here is that we're actually explaining what is meant by controlled access and how that process is going to be implemented by the archive. One of the points that you may wish to add to this module is around who it is that is actually responsible for making those decisions regarding access. So when we say it's upon approval, what does that mean? Does it mean that there is a data access committee? Does it mean the PI is contacted and reviews the applications? How does that process actually work? It's also important to clarify that what data is actually going to be shared. And this is really because there is greater harm or risk of harm to the data subject the more data that is being shared. So whilst it might be the case that it's only the data which is covered by this consent form that's to be shared, if you also are going to include some clinical data or other forms of data which are coming from other sources, that increases the likelihood that someone could be re-identified, and thereby it increases the likelihood of risk of harm to that subject. So it's really important to explain to them exactly what is going to be shared when the sharing happens. In terms of using the modules, you can find them on our website. So our website is ghga.de. And if you go to the resources tab, you'll see that there's a resource there called the Consent Toolkit. There's through the web page, it gives an explanation about the idea of the consent modules, and it also gives a link to Zenodo white paper, which contains more information about how you can actually implement the consent modules and obtain the text in English and German. One of the really useful things I find with the white paper is a checklist to help you check for common issues. So the way that we envisage the modules being used is, because they're modular, is that you incorporate those into the consent forms that you're already producing or the information that you're providing to data subjects. And then it's really important that you're going through afterwards and actually making sure that there aren't things like the change in terminology, that there isn't sort of a change in the way that language is being used, things like that, that the information is consistent throughout, that we're not saying you're not doing something in the consent that you'd already drawn up. And then the consent modules are saying that actually that is happening, because then that's very confusing and not really useful to the data subject. And all that information is included in the white paper about how you can go through and do that, and the sorts of common problems that you might want to check for. Now, the second tool I'm going to present is our legacy consent toolkit. And I'm just got one slide here, and then I'm going to risk doing a live demonstration of the toolkit. So we'll see how that goes. The idea behind the legacy consent toolkit is to really assess whether consent forms that have been used previously enable the secondary processing of data. And in particular, what we're thinking about is consent forms which were perhaps collected pre-GDPR and whether they meet current standards. And so one of the challenges probably that you would have experienced as researchers is if you're collecting data, say a longitudinal study or a cohort study, you may be collecting that data for a long period of time. And one of the challenges that you may face is that since GDPR has come in, there are these standards around consent. And what we don't want is, or try and avoid as much as we can, a situation whereby the consent doesn't allow for reuse of the data now because the consent doesn't fulfill the current standards. And so one of the ideas that can help address this is this idea of legacy consent. So we go back and we can assess the consent by through the sort of prism of modern standards and see whether actually it still works in a legal sense. Now, we've produced the toolkit in two formats. We have an online web tool, which is available in English, and that's what I'm going to give you a demonstration of. And we also have some downloadable worksheets and a legal paper, which are presented in German. A big caveat, and that you'll see this pop up, I think, throughout the documents. Obviously, don't interpret the legacy consent toolkit as formal legal advice from GHGA or any of the institutions that make up the consortium. The idea behind it really is that it's helping you, it helps to guide your own assessment of your consent form, and you should always consult with the data protection officer or similar relevant persons at your institution once you've used the tool. We see it more as kind of indicative rather than any kind of legal verdict. So I'm just going to stop sharing briefly, and I'm going to bring up the tool. So I'm on our website, and if you go to resources and legacy consent, you'll be brought to this page. And this gives a bit of an introduction to the module. There's the link there to the paper, which was published around the module, and a little bit of guidance about how you can use it. The consent tool itself, if we scroll down, again, you're asked to kind of confirm that you understand it's not legal advice. It's only there for your guidance. So if I click on proceed, we can see that we're into the legacy consent toolkit. The layout of the tool is we sort of have these three sections. So we can see here where it says, are you using this tool to review a legacy consent form? This is the area where we're going to actually get the questions that are guiding us through the assessment. We have a section over here, which is further information and guidance, and this will update as you respond and answer the questions, and it provides sort of information about how you're expected to answer the question in terms of understanding what the question is, what are the things that you should be looking for when you're making this assessment, etc. And down here in this grey area, you have the option to reset all of the fields. So if you want to go back and enter in the information again, it's easy to do. Also, when you reach the conclusion of an assessment, so either the tool suggests that legacy consent may be possible, or it says that it's not possible, you'll have an option here appear which allows you to download a report in various formats of the assessment that you've done. The idea being that then if you're having a conversation with your DPO or data protection teams, you can take this to them and use that as sort of indicative information about the assessment that you've carried out. Again, it's not a kind of formal legal verdict on it. So if I start doing an assessment, you can see we have a fairly easy choice here, and we're going to choose that we're going to a legacy consent form, and we can see that we get our further information and guidance is updated. And the first question then is, does the consent form or its collection fit in with these key requirements of the GDPR around consent? So freely given, specific and informed and unambiguous. And we also advise other principles from the GDPR around data minimization, pseudonymization and anonymization where possible, and that there are appropriate security standards. And what we can do, we can select yes or no, and for the sake of argument, we'll assume that the consent form we're looking at does meet those aspects. Now what we need to do is really start thinking about the primary and secondary processing. So the primary processing is the consent and the processing that was envisaged when the consent was designed. And the secondary processing is that sort of future processing that we want to do. And what we're advising is that we're looking at two elements of risk to the data subjects, the likelihood and the severity of risk. And the first question here is, has the information context changed? Now, of course, in many circumstances, the data that's been collected won't have changed since the original consent. But if you're working with biospecimens and other kind of biological samples, it's possible that you've gone back and actually reanalyzed those samples, and so the data has actually changed. And this then affects the risk to the data subjects because there may be more information that's being extracted with newer technologies since the consent was collected. And so what we can do is we can say, well, yes, in this case that I'm imagining, the information content has changed. Did we describe the usage in that pre-consent information? And if we go back up, we get some guidance on what we should do. And we will say, yes, sorry, I realized the layout's gone a bit skew-if, and that's just because it's so zoomed in, but hopefully you can see it anyway. Then we need to think about the actual comparability of the processing purpose. So what was the original processing purpose when the consent was collected? And we offer a number of options here. So it's either a clinical trial, was it routine healthcare data, was it healthcare with scientific research, or was it purely scientific research? And if we select an option, we're then asked, is there a concrete data processing purpose? So is there something specific that we're allowed to do with it? Or is it a kind of a broader consent that's been enabled? And if we say that there was a specific purpose, we can then have to do an assessment, see whether those purposes are compatible, and we'll say that they are. Now we need to think about who can actually do the processing. So again, does the consent specify a particular data controller? And we will say no this time. And then we think about the entity that actually wants to do the secondary processing. Is it a university or is it a case group? And again, obviously, scroll up. You can see that there is a definition of what we mean by case group and universities. Go back down. And if we say, we'll say it's a university because we're mainly from universities. And now we need to think about the technical and legal risks of the proposed processing. And so there is quite a bit of information about that up here. We can't really see it because of the Zoom, but it kind of guides you through the aspects that you need to consider when you're thinking about this. And we'll say that in this case, it's going to present greater risk. So the new processing increases the risk to the original purpose. And we get to the end because it's now saying that, well, because that risk is increased, then legacy consent is not going to be a suitable legal basis because that's additional risk to the data subjects that they didn't consent to. And if I go back up to the page, you will see that we now have an option here to download a report. And so I'm just going to download it in PDF form. And tell me if you actually see the report, does it come up? And so we can see that this is the report that we generated, and we can see the questions that we answered and the answers that we gave, and the recommendation of the toolkit. So that's sort of how we use it. Obviously, that's a very quick overview of it all. We are looking to sort of constantly improve it. This is only the first release. It went live today. So it's very new. So if you have any feedback, there's both links in the app and within the web page that you can use to contact us. We'd particularly like to hear if you have suggestions on additional functionality that you'd like to see within the tool. And of course, if there are errors or anything like that, obviously we don't think there are, please let us know and we'll go in and correct that. So thank you very much for listening, everyone. They were the tools that I wanted to present today, and I'm happy to answer any questions